Supreme Court of Florida is now in session. All have cause to plead. Draw near. Give attention. You shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning. Welcome to the Florida Supreme Court. We'll start today with case number 21-651, City of Tallahassee versus Florida PBA.
May it please the court, I'm Phil Padovano for the City of Tallahassee. With me at council table is Mark Caramenika for the News Media Coalition. Let me begin with the general principle that an on-duty officer who uses force against a suspect is not acting as an individual, but rather as an agent of the government. The officers here were acting in an official capacity by the authority vested in them by the City of Tallahassee. At no time were they acting as on their own behalf as individuals. And so for that reason, they cannot be regarded as persons the way that term is defined in Marsy's law.
Why?
I think there because
let's say I grant you that he's not acting in his own, in his own capacity. Does he cease to be a person though, even though he's acting? For example, am I not a person at the moment because I'm wearing this robe?
You are a person, and they are persons too. But the question of whether they are persons within the meaning of this law depends entirely upon how that term is construed within the meaning of the law. It could mean a human being. That's a well-accepted definition of a person, and if you choose to interpret it to mean that, in this context, we lose. No question, they're human beings. I get that, I understand that. But I think a better interpretation of the term person in the context of this law is an individual. They were not acting as individuals, they were acting as agents of the government. They were in fact, the government on that day. When they went out there with their weapons, the power to arrest people, the power to detain people, the power to use deadly force against people if necessary. They weren't acting as persons in the way that law is, the way that word is defined here.
I guess my larger question is, I wonder why you've put so many eggs in this basket. Isn't your much stronger argument waiver? Isn't your much stronger argument the fact that while this person is a person, perhaps the fact that he has his name on his lapel tells us something? Can I hear from you on that? Like, let's say we don't agree that we're going to make this distinction between acting as a person and being a person, and we're just going to, in fact, conclude that a person is a person. Make the argument about waiver.
Waiver? I'm not sure I'm following your question.
Well, if I'm a person and I've disclosed my identity, haven't I waived my rights?
Well, I think that's a good point. I don't think it's a point anybody made in this case, but I think I would say that's correct. I mean, in some respects, the identity point is I mean, I think that goes to the identity point, or the anonymity point, if I could call it that. Police officers walk around with their names on their chest. So, yeah, it's kind of hard unless it happens to happen somewhere where nobody is watching. And we all know there are cases where people videotape these things with iPhones.
Just as an aside, did we not classify police officers as persons in stand your ground type of cases?
You did, Your Honor, but I think that there is a very different, there's a very strong difference there. Our whole argument is based on the fact that there's a difference between the definition of a person as a human being or as an individual. And I think the court has to pick the one that fits the context of this law best. In the context of the stand your ground law, I think human being works fine, because there the person was not acting as an individual. He was defending himself against a charge made by the government, perhaps one of the most personal, one of the most individual things you could think a person could do.
Well, but, to the same extent, in the facts here, the officers were purporting to act in self-defense. Isn't that correct? And that the whole the factual context here, so I'm a little struggling to see how this is so dramatically different,
Well, there are...
given that underlying commonality in
Let
what
me
the
say
officers were actually doing.
Let me say in answer to your question that there are similarities. I concede that, but I think there is a huge difference between defending yourself against an action taken by the government and actually using the authority that you have as a police officer to affirmatively do something. These officers filed a declaratory. They initiated the action. But let me make one other point about that, Justice Kennedy, that I think is important. And our whole case here is about context. If there's nothing in the stand your ground law that would prevent the court from saying that we're going to look at this as, we're going to treat this person as a human being and not as an individual. Whereas in the Marsy's law, you would have to contravene a whole lot of things in Marsy's law to use the human being definition. You would have to go directly against the purpose. You would have to make almost every one of the provisions in Marsy's law meaningless. You would end up with a decision. You'd end up with an opinion that could be read to say essentially that Marsy's law was enacted for the purpose of protecting the police. It was not.
Counsel, I mean, that's an overstatement. Is the consequence of your position on the victim issue that the widow or widower of an officer killed in the line of duty would not get any of the benefits of next of kin, that all of the panoply of victims' rights to be present, to be heard, et cetera, et cetera? I mean, is there any way that we could treat that any differently than what you're arguing here?
Well, I don't think any of that makes any sense in the context of a police officer. A police officer, if you look at the panoply of rights.
So the widow of an officer killed in the line of duty is different from the widow of a non-police officer victim?
No, there are admittedly some rights that could be exercised here.
But only because that person would fit, that widow or widower would fit the definition of a victim.
Right.
So I don't see how you could include them and exclude the officer.
Well, I think because the text of Marsy's law simply doesn't support that. If you look, for example, at A3, it gives the victim the right within the judicial process to be reasonably protected from the accused. So we're really going to say that police officers, they're the ones who protect us from the accused. It doesn't make any sense. And in the very next sentence is, however, nothing contained herein is intended to create a special relationship between the crime victim and any law enforcement agency. Well, here, Marsy's law, the text of Marsy's law, is setting up a distinction between law enforcement and victims. Now, I don't know how you could be both and read that sentence fairly.
Counsel, could you address why you think you should win on your third argument?
The third argument.
Now, this was touched on briefly on a point, an aspect of it related to it that wasn't actually raised, but on things that's actually been argued. Why do you think you should win under your third argument?
Well, Marsy's law, excuse me, of course, we begin with a proposition that there's nothing that explicitly says that a victim can remain anonymous, and I think you have to consider that against the backdrop of the existing law. The Public Records Law, Chapter 112, provides that police officers' addresses and phone numbers and other identifying information is confidential, it's not public. But their names are public. And so against that backdrop, we have Marsy's law, which, I mean, and there's so many other instances in the law. The First District was kind enough to outline a number of them, where there are specific statements that a victim's or that a person's identity is protected. I don't have to look any further than, for example, juvenile court proceedings. We have a rule that says you don't give the name of a juvenile offender. So I guess the question would be, how hard would it have been to do that if that's what was intended? I don't think that's what was intended.
But I think, isn't there a difference, though, between statutes that specifically list out things that are exempt, like name, address, social security number, et cetera, versus this text, which instead of listing specific things, just describes a category of things. I mean, do you agree that if we don't agree with your sort of background law position and we just look at the category of things that could be used to locate someone, wouldn't a name fit within that?
I think a name could be used as a way of locating someone. I do.
So it wouldn't be plausible to exclude a name from that category.
But of course, now we're getting into an interpretive argument that the respondents want to avoid on the first point. I mean, we either are going to do this as a strict constructionist or as a textualist. So I guess what I'm saying at some point, my argument on the third point, there really are difference between those arguments, I think, on both sides.
But could you elaborate on that? What's the strict constructionist? What could you explain?
Well, I think what I mean by that is I think a strict constructionist would be okay with the term person, meaning anybody who happens to be human, because after all it says that, and we don't really need to look at the context. A textualist would look at the context, but by the same token, a strict constructionist would have to say, well, wait a second, this law doesn't say anything about anonymity.
How much, when we're interpreting a constitutional provision, and especially one that if we're interpreting constitutional provision, should we assume the same types of kind of legal conventions that would apply to a statute? Should it matter?
Generally, I think that's true. Yes, I do. If the court doesn't mind, I'd like to spend a few minutes that I have on the second point, which is the need for a neutral determination of victimhood. And this particular point, I think, could end up to be a disaster if we don't get it right. Because if you don't have some neutral determination of who is the victim and who is the defendant, you can have a situation where people are out in the street, you have an assault case, one person says he assaulted me, and then the other person says, well, no, he was the aggressor, I was just defending myself. Do they both get to claim that they were victims? I mean, I think that throughout the text of this, throughout the whole thing, there's this thread that there has to be a proceeding. It starts in the very beginning to achieve justice and ensure a meaningful role throughout the criminal and juvenile justice systems. And ensure that crime victims' rights are respected in a manner no less vigorous than those of the defendant. Well, the defendant's rights all have to do with a proceeding. The enforcement mechanism for Marsy's law in subsection 11C, the victim may seek enforcement rights in any trial or appellate court before any other authority with jurisdiction over the case. That sentence implies to me that there has to be some sort of a proceeding in which you can actually claim that somebody has said that you were the victim and somebody else is, in fact, the defendant.
What do we make then of the statement that the right attaches at the time of victimization, the express provision of that?
I'm sorry, sir.
What do we make then of the express provision that the right attaches at the time of victimization?
Well, I don't think that's determinative, because I think there's a difference between the time when a right accrues and the time when it may be enforced. There are lots of rights that accrue before they can be enforced.
So then you would concede that the right has accrued?
Yes, assuming that somebody subsequently determines that that person is a victim. I would also point out that this court's rules under Marsy's law, every single one of them, if you'll take a look at them again, assumes the existence of a proceeding. I think the court had it right there. The court had in mind that this isn't going to be something that's going to be litigated in the streets. It's going to be something that is ironed out in court.
Of course, our rules deal with proceedings.
I'm sorry?
Our rules deal with proceedings.
Right.
I mean, that's just inherent in what we're dealing with.
Right.
We're going to be dealing with proceedings.
Well,
correct?
Right. I understand that. But all I'm saying is it's consistent with all of these other provisions in Marsy's law about the need for a proceeding. I don't think we can have a situation where people can self-declare as victims. There are a lot of times when there might be a criminal act and not yet shown that there's intent. Maybe the crime isn't yet ripe enough to have been known as a crime. I mean, how do we know who the victim is at that point? Maybe, we've used examples in the brief about something that may be a civil case until it ripens into a crime.
Why don't we focus on the facts of this case? Is it the city's position that the officers in this case were not victims at the time they were assaulted?
Well, first of all, I think they were not victims because they were not persons by any fair reading of Marsy's law. So I answer to that, no, they were not victims. But if I take the assumption of your question, we do concede that they acted properly. We do concede that they were threatened. So if that helps in your determination, we do make those concessions. I'm down to 10 seconds away from my co-counsel's time, so let me sit down. Thank you.
Good morning. May it please the Court. Mark Karamanek of Thomas & LaCicero for the news media parties in this case. I want to start by following up on 2 points. I know there's been some discussion about whether identities are protected under Marsy's law. And I think 2 points to make here are, in the Constitution, when identities are to be protected and held confidential, the one constitutional provision we've been able to identify was clear about that. And that provision relating to the identities of medical marijuana patients made clear that identities were protected. So when the Constitution wants to protect identities, it does it explicitly and it's clear. And again, as my colleague mentioned, context matters in this case. And when we're talking about criminal proceedings and the criminal process, the identity of a victim is inevitably going to come out during that process as it flows through, because the defendant has a right to confront their accusers. So it makes sense that identities
that's true in some cases, but if the perpetrator of a crime is deceased, then that wouldn't be true in those circumstances, would it?
Well, and that's the part of the irony in this case, is that we have a situation where your alleged victimizer is deceased and presents no threat to you anymore, and so much of what Marsy's law is designed to protect simply falls away, and it results in someone in this case where you take offensive action and actually kill your alleged victimizer, then it would result in perpetual anonymity, and that in our view would simply turn Marsy's law and the policy reasons that are baked into the law as to why it's there just simply on its head. Those are the sort of absurd results that we think canons of construction counsel this court to rule in a manner that avoids that. So that sort of absurdity there would be something that Marsy's law does not contemplate, and again all the protections that is there to enforce just simply don't apply. The other point I wanted to make in my brief time is a point that the DCA made, in that it found that there was simply no conflict between Marsy's law, Article Section 16, Article 1, Section 16, and the Public Records Access Provision, Article 1, Section 24. Given the reading that the first DCA gave to Section 16, we believe that there is a conflict that needs to be resolved, that Article 16B5 does not create an explicit exemption to the Constitution and the right of access. When that's so, the Article 1, Section 24 says that a confidentiality carve-out needs to be specifically created, and here we simply don't have that by its very terms, and I think some of the issues we're talking about today make that clear. We don't know who necessarily a victim is, when those rights incept, when they may fade away during the course of a criminal proceeding, whether they've been waived, whether somebody even wants to assert those rights. there are all these variables, the scope of what is actually protected if there is a true victim. All of these things need to be considered, and it really results in a provision that in certain circumstances can restrict access to public information, but it's not a one-size-fits-all monolithic exemption. And because of that, there is a conflict where this court needs to consider the policy provisions of Article 1, Section 24 and Marsy's law and come down with a ruling that gives effect to both. And our position here is any ruling that really sort of cuts to the core of the true public accountability type of information that is at issue here, police accountability. We've cited a wealth of case law that recognizes the importance of being able to hold government and police action accountable. That needs to be balanced against the Marsy's law provisions, which really, as my colleague said, are designed to provide rights during the course of a criminal proceeding, and balancing those rights really comes down to recognizing that police officers, in the scope of their official duties, do not have victim status under Marsy's law. And my time is up, so I will end there. Thank you.
Thank you.
Good morning, and may it please the court. My name is Luke Newman, and I represent the respondents. My individual clients are people. They are police officers. In two separate incidents, both men were attacked, essentially unprovoked, with homicidal violence. Both of my clients responded with force. They both shot and they both killed their attackers. Each then affirmatively opted into the protections of Marsy's law. Now, my colleagues on the other side say that they're not people, as that term is used in Marsy's law, and that they don't get the protections that the law affords. The reason they say this is because the term person does not include a police officer. And as we touched on earlier, Justice Curiel, they might not be that specific. It might not include any public official who's working in the course of his or her duties. My clients have suggested a non-specific carve-out in the language of the Florida Constitution. They've also accused my colleagues, of ignoring the context of the language. But the language says that it should apply to every victim. A victim is then defined as a person, which we've discussed, and then there's this long mouthful of a person threatened with physical harm or potential harm, and then there's an or, and then we get an easier to handle victimization definition. It says a person against whom the crime is committed. No carve-out, as suggested by my colleagues, exists in the language. This is a request for an after-the-fact ad hoc exception. It's a claim as to lawmakers' unenacted desires in a matter that's not covered, like the exception.
I'm sorry to interrupt you.
Yes, sir.
I think the two issues that are most important are the triggering event issue and then the anonymity issue. Could you focus first on the triggering event issue?
Sure. I'll talk about.
Can I ask you something specific about
anything?
that?
Yes,
So
sir.
obviously the strongest point on your side is the rights attaching at the point of victimization. But I think the other side has a lot of good points about the fact that the overall context of this provision implies that there's going to be some sort of criminal proceeding underway. And specifically, in subsection D, it says the provisions of this section apply throughout criminal and juvenile justice processes. So could you help us understand how someone, this triggering event issue, and how someone even can sort of, for purposes of this, can sort of become kind of designated as a victim?
Sure. Let me start with the last part. Obviously, the language says it begins at the time of victimization. So a suggestion that there needs to be some other kind of triggering event later on, it would necessarily have to be later, right? I mean, they're saying there has to be a neutral determination, things of that nature. By definition, wouldn't that have to be later in time? So I don't think there's any way to give a fair reading to at the time of his or her victimization with the idea that they've suggested, which is that there's some necessarily later point in time where it actually kicks in. Does that answer that portion of the question?
Well, I mean, I understand the problem. The interpretive problem that we have is how to make sense of this thing in its entirety. there's some aspects of this that are kind of unorthodox from what you would, in terms of how the provisions interact. It's things you see in a legal document. We have to kind of make sense of the whole thing. And it seems like a lot of this does assume, the sort of the symmetry between defendants and victims and the nature of most of the rights that are involved here. It does assume that it's taking place in the context of a criminal proceeding. Obviously, there is the rights attaching to victimization. I'm asking you to help us kind of make sense of all that. Because, do you agree that could it just be someone sort of declaring them, they've suffered some kind of harm or something has been done to them, which is different from the concept of a crime, right? So the whole concept of a crime kind of implies that you're already sort of in the realm of, some sort of determination by a government authority that a legal test has been made. So do you agree that people can't just sort of declare themselves quote unquote crime victims?
Generally, I think that's fair.
So then there has to be something, right? So what is it?
Well, if there's a dispute about somebody's crime victim status, and this happened in this case, the text of Marsy's law allows for that individual to go to any court, trial or appellate, and pursue their rights in any court. So where it's disputed, I don't think somebody can wake up and walk into his or her driveway and say, you know what, I'm a crime victim. But I think if there's a dispute about somebody's status as a crime victim, the text allows that individual to go into any court and make his or her claim. And then let me back up. I just want to back up a little bit to the first part of your question. If we're going to read, as is suggested, this language is requiring some later triggering event, our position has always been that that would create absurd results, and that it would, instead of protecting every victim, it would carve out individuals such as my individual clients in this case, whose where the offenses were committed by an offender who dies during his or her apprehension. So then we create this arbitrary kind of indexing of victims where, well, you get these rights now because the person who victimized you is alive and was, identified or arrested or whatever. The triggering event suggestion by my colleagues is pretty nonspecific. And then somebody else who's victimized by an individual who, say, commits suicide, maybe contemporaneously with the offense, or then dies during apprehension or in some other circumstance. Well, you don't really get these because there's not a triggering event. I know it says at the time of your victimization, but we don't have this other triggering event that's necessarily later. So that's kind of the two-pronged response to that argument by my colleagues. Also, obviously, going back, because we've been, throughout the pendency of this case, we've been accused of not heeding the context. It goes back and it contradicts what the text specifically says, which is it applies to every victim. Does that handle that fairly, sir? And then I think you brought up another issue that was
the anonymity point. Which,
sure.
That's obviously, because really the anonymity issue isn't about police. That's to the extent that this issue arises, we're being asked to say something that would affect all victims.
Right, that's correct. And so what we've relied on throughout the pendency of this, the whole controversy, has been that the broad net that the language throws covers anonymity. And what the language tells us is that the victim has the right to prevent the disclosure of information or records that could be used to locate or harass him or her, or which could disclose confidential or privileged information. And so we've throughout argued that the term could, it introduces this notion of possibility, and that also the language is so broad that its presumed point is being general and broad is to provide general coverage.
Well, yeah, but it doesn't read out of the Constitution the confrontation clause, right?
Right. Certainly there's a confrontation clause.
So in order to confront my accuser, I have to locate him or her, right?
The confrontation clause, right. If you're a criminal defendant, right. The accuser, you have a confrontation right, absolutely.
Okay, so if we understand that the confrontation clause is a meaningful check on this language in Marsy's law, doesn't that preclude the argument that the victim's identity can forever be sealed away? Doesn't the confrontation clause act as a safeguard against the bottomless pit of anonymity that you seem to be arguing for in the breadth of that language?
In a criminal trial, we're talking about?
For example.
Yeah, absolutely. Absolutely. I don't think you can have an anonymous victim in a criminal trial. Now, I don't concede, though, and we're not here on a criminal procedure issue, okay, but I don't concede necessarily that doesn't mean that the judge might close a courtroom. They do it with child sex crimes all the time. So I don't concede that means that If I'm accused of committing a child sex crime, that doesn't necessarily mean that all my friends get to sit in the courtroom during the trial, even though I have a right to confront witnesses and have a public trial.
I'm not sure how much that particular fact pattern helps you, because often the reason for anonymity in those cases is more to protect the victim than the accused. And here you don't really have the same fact pattern, right? It's not a great analogy.
No, we're off the fact pattern. I just want to make sure that when I'm saying I agree with that your confrontation rights still exist despite the existence of Marsy's law, that I'm not conceding then if we get into an actual criminal trial later, that I'm not conceding anything in that vein.
A related point is the one that I was discussing with your friend on the other side, which is what about waiver? What about the fact that a police officer, generally speaking, as part of his or her mission, is identified publicly, wears his or her name on a badge, in fact, regularly in the line of duty identifies him or herself. Indeed, I think to be an effective law enforcement officer wants to be known in the community where he or she is policing, right? Helps to generate informants, leads. Being anonymous seems anathema to policing as we understand it in a free democratic republic. Help me understand how being a police officer doesn't waive this claim of full anonymity that you at the edge of your argument seem to be asking for.
All right, let me address it with a few different strokes here. First of all, I think that the waiver argument would have, I think, popped up in Peraza. Wouldn't that be the same argument we have seen there, that you've waived your right to invoke a stand your ground law that was enacted maybe after you became a law enforcement officer, when you put the uniform on and you put your nameplate on and you walked out in public and began to work your beat?
The difference there is that by putting my nameplate on, I am literally telling you my name, which is a little different from saying I'm not going to defend myself, because, I mean, you're also putting, a sidearm on. So I don't think you're waiving your right to defend yourself. It's much more the fact that I'm openly, and like it says Smith on Officer Smith's lapel. What do we do about that?
Let me take you back to the timing issue that we were discussing earlier. Then we talked about the rights being created at the time of victimization. When you put the nameplate on, you weren't a crime victim at that point. You became a crime victim later when you were out there working your beat. And so, does that make sense? That's I want to make sure that you put the nameplate on, you get out there, and you haven't been victimized at that point. The victimization happened later on when you're out there on the street. And I want to say one other thing. There's been this kind of undercurrent in this case throughout that the finding for my clients, John Doe 1 and John Doe 2, is kind of authorizing this KGB-style secret police force that, there's never been any confusion that in the incidents we're here to talk about today, that it was a Tallahassee Police Department officer that took the axe to give this case the gravity which it has. We're not advocating for a secret police force. I think that's an unfair characterization.
Well, no, So on the face of the Constitution, what we're protecting against is harassment, right? Location harassment, but not necessarily immunization from investigation or charge. I agree. I guess, and this now pivots to another piece of the argument, which is can be used to locate. Obviously, if you push that to its logical extreme, a physical description could be used to locate the officer. I don't know how many officers are over 6'7" in Tallahassee, but if, let's say, 2 are, and you said, I'm not disclosing the name of the officer, but I will say that he or she was 6'7". Can that be used to locate and harass the officer and therefore needs to be suppressed?
The way we've argued this because we've relied on the terms could, being placed into the language, and the way we've argued this throughout, and I hope this answers your question, is that unless it would be shown that it could not. So I guess your question about the unique height of an individual, and the way we've argued this throughout has been unless it was shown that it could not, that you could not be located through that. If there was a situation where you could not, we want to know the names and information and history of every officer who's over 6'7" in height, and your client doesn't fall into that, I don't think you would have a Marsy's Law claim.
But really, the point is you don't have to get anywhere near the logical extreme to treat a name as something that could be used to locate someone.
That's been our position throughout, and I think maybe I'll let the district court opinion do some talking for me there. I mean, they were pretty clear about it. The name is the first ingredient of any such, pursuit. And so I don't grasp fully the argument that the name is, when we look at language that's as broad and as encompassing as language that we're dealing with here, saying that it doesn't apply to a name,
I guess the point, I think the point isn't, the point would be, do we need to take common sense into account and just acknowledge that, especially in the course of criminal proceedings, you're almost always, absent some unique subcategory of victim, you're almost always going to know the identity, just that mere fact, the identity of the victim.
In the category of, and we're talking about a criminal prosecution?
Right.
Certainly.
Certainly. And clearly that's the core. Even if there are some cases where there will be a clear victim and yet there's no process. You acknowledge that the core of what this is addressing is criminal processes. The whole spirit and thrust of this is to have a symmetry of treatment and rights between victims and defendants.
I agree with that.
Defendants imply that there's a process, right?
I don't agree with, our position throughout, and again, the district court opinion does some work for me here, is that it's nothing in this language requires the imposition of a criminal, because let's talk a criminal process. Because let's talk about, we go back to an individual who's victimized by somebody who isn't apprehended through the victimizer's death. There's no criminal process. Are we going to say, oh, you're carved out of every, and we're not going to provide you these protections because the person who victimized you happened to be killed before he could be apprehended? I don't know how you can read every and then say all these rights apply, and say except you people, because you people had the misfortune of being victimized by somebody who then committed suicide or got killed or died otherwise prior to being apprehended and effectively processed.
Well, but the other side of that is, I think what you're saying on your identity point is that, well, if you end up if you're a victim and you end up going through the criminal process, criminal proceedings, you're not going to get your identity protected. But if you happen to be a victim where the victimizer is gone and therefore there's going to be no criminal process, you're going to get the benefit of that. So it kind of creates an asymmetry there where most victims are going to have their identity revealed just in the ordinary course of things of going through the criminal proceeding, but a certain subset of victims, assuming that your argument on that's accepted, would not have their identity revealed. That does seem kind of an anomalous result. Maybe that's what the language requires, but it does seem a little odd.
Let me go back to what I was talking with Justice Curiel about earlier, about when I said I'm not ready to concede that if you're a victim that you that there aren't protections that would happen in the context of a criminal prosecution that could effectively protect your identity. I'm not ready to concede that. I think this court has handled, and the U.S. Supreme Court has handled those kind of cases in the past. We're not here on a criminal procedure question, but I think that there are mechanisms. I don't think that there are mechanisms. I know that there are mechanisms for protecting the identity of a victim in the context of a criminal prosecution of a living defendant. And I think that the broadness of Marsy's law language would allow certain victims, if they so choose, if they're motivated to do so, to go into a criminal court and say, I want you, Mr. Circuit Court Judge or County Court Judge, to protect my identity in the following manner while still honoring the confrontation rights of the criminal defendant. Does that make sense? So I don't want to get into criminal procedure, but I'm not conceding that a victim of a crime where there's a living criminal defendant who's being prosecuted by the state can't come into court and with representation or otherwise and say, I want to put in the following procedural rules in the context of this case that would protect my identity. So I think that if it's important enough to litigate it, I don't necessarily agree there's always going to be that dichotomy there.
So under your reasoning, every single police report that gets filed from this point on would exclude a victim's name out?
If the victim requested?
Yes.
So the victim requests after victimization, before the report is
the
what?
officer is filling out a police report for, a purse snatching, for, carjacking, whatever the case is. They're filling out the report and they say, I'm a victim under Marsy's law. Every single police report, every clerk's office, everything, every name is now excluded.
If the victim opts in. So our position has been this is an opt-in provision. So let's say if something got stolen out of my car, I want to make a police report. Whatever got stolen out of my car is sensitive to me for whatever reason. Maybe it's individualized reasons. I'm invoking Marsy's law protections. I don't want it released publicly. My information or information that could lead to me being identified, yes, I think that's provided for in Marsy's.
And if they have a distinct physical characteristic, that's also excluded from every police report.
If that could lead, I would say you could identify me based on my distinct physical characteristic, then I would agree with that. Sir? Something like that, or a height, an unusual height.
Can I ask you one thing?
Anything.
So in terms of the scope of what you were initially asking for in your petition in the trial court, it seems like this case has evolved to where there's been a lot of focus on the identity issue. But the petition says enter a preliminary order enjoining the city from releasing any personal information that could be used to identify or locate. Has the case evolved to a point where the only piece of information that's at issue is the name, or is there some? If the name weren't included, would there still need to be some sort of acknowledgement that at least partially part of what you were asking for would still be at issue?
No, I think that, and we talked about this, there's not a record of this, but we talked about this when we were in circuit court litigating this issue. I think that for instance, the badge number, I think identifying information is out. So the name doesn't include, we've argued a lot about names, I agree with that, but it doesn't include just names, it also includes the badge number. I see I've got 2 seconds left.
You can finish up.
Okay, thank you so much. I'm going to quote my colleague from the media's brief where it says, these officers, meaning John Doe 1 and John Doe 2, may be exemplary officers for which the community should be proud. I submit to you that the videos have been released in this case. They've been published to the public. My clients are exemplary officers for which the community should be proud, and we are proud to submit their case on their behalf. Thank you.
Is that 3 seconds?
Supposed to have 5 minutes. You can have 3 minutes.
Oh, thank you. Let me just say, first, let me agree with Mr. Newman on that point. We certainly are proud of the officers. The case is not about them. It's about a much broader principle, I think. Justice Muniz, to go to a point that you made about the need for a proceeding, one thing I neglected to say is in 11C, it actually says seeking enforcement of the rights in a trial or appellate court. And then it says, or any other authority with jurisdiction over the case. Now, what that tells me in plain English is that there must be a case of some sort, whether it's somebody files an arrest warrant and starts for a bail hearing. Something's got to happen somewhere.
Well, yes, but earlier you conceded. Let's finish that sentence.
Yeah.
There has to be a case in order for the right to be exercised. But you've conceded that the right is already accrued.
That's correct.
Okay.
I do agree with that. I firmly agree with that. If there is a right that can later come into being, then maybe that person can get restitution, all sorts of other things can occur. Let me say counsel has characterized our argument as using substantive canons, going beyond the text, making policy arguments. That is not what we are arguing. Our argument is based on the text. And I don't think it's an unusual or incorrect argument to say that the term person can be construed in different ways. We know that the United States Supreme Court said that state officials are not persons within the meaning of Section 1983. Obviously, they're human beings.
Can you direct us to a single constitutional precedent you want to own where a human being is deemed not a person for purposes of the law? That isn't a tort case. Oh. I'm just saying that the canon of cases that hold that a human being is not a person under any circumstance is probably not a canon of cases you want to own.
Justice Carrillo, that's not my argument. A person can be a human being under many and most circumstances, but in some circumstances, and the Section 1983 case is
those are torts.
A good example.
Let's take torts off the table.
Right.
Any constitutional right given to persons that excludes any human being, cite a case for me that you want to be part of your brief on that. I submit to you there's no case that assigns a constitutional right to persons that you want to own that excludes some human beings. Do you concede that?
Well, I don't know of one, but I do know that the courts have consistently, I mean, a corporation.
Plessy.
I'm sorry?
Plessy.
Yeah.
Okay.
All right. Well, let me just say that on your point about the anonymity, I think if you were to, I would commend you to the amicus briefs written by Sheriff Chitwood and Sheriff Galtieri. There's a lot in there about that, and they actually believe that this will make their job harder if police officers have end up remaining anonymous. Thank you.
Thank you.